Happy Vijayadashami to one and all. Today is a very auspicious day. We will make sure that this year is fruitful to every one of us. Every one of us in our team, in our family. I pray to God that we clear with very good marks. Okay. So let's start today's class. We have 16 participants. Thank you so much for joining us today. I thought everybody will be taking a holiday, but it's important that we read, right? So we will start with a good kickoff. From this time, you dedicate yourself 1 year for UPSC. Okay. So let's start today's class.
The same to you, ma'am.
Oh, thank you so much. Thank you for, in fact, being present today. Okay. So I'm really delighted. 17, but yeah, tell me, sir.
Class looks like a biological class, biology lecture today.
Okay, okay, sir. Okay. Tell me, please. You're not there? Okay, we will start. Not able to hear me? Let me know. Okay. So today's class, you may be thrilled by the first slide. Yes, we are in law optional class only. You see, what are these? It is a brain, lungs, liver, heart. What are these called as? They are organs of a human body. Everybody will know that. But likewise, we can compare this whole body to our state. Okay. So that the state also is having its own organs. But today's state only is having organs. What about yesterday's state? Yesterday in the sense, when the Mughals were ruling, what happened? When the British were ruling, what happened? That is the most important thing that we have to see, because today's state is not something like it jumped out of nowhere. It is an evolution. So what happened during the Raja's rules? That was the first thing, right? When Marathas, all those people were ruling in south, we have Cholas, Pandyas, Pallavas, and you have the Mughals. All these Rajas were called as monarchs. Why they are called as monarchs? Because their words were law, and their whatever they interpreted, these law is justice. Okay, and whatever justice they feel of doing came to be executed. So you see, entire function of today's state rests in a single person. This single person is called as a monarch. But this was separated into different organs, and one person owes to this separation idea. Okay, now if see before us the state appears to be separated, so it is not something new. But in earlier days, when one person is holding all powers, separation was a unique idea. It was almost like, see, some invention sort of thing. Okay, so who is that person? What is that concept? Will be our today's discussion. Yes, we are going to talk about the organs of state and how they are separated, which is the doctrine of separation of powers. Everybody will know the basics, but as we build up the classes, we are going to see a lot of articles, just like a spider's web. So I request everyone to be keen and attentive. Okay. So when you're talking about organs, first, the creation organ. The organ which creates law is legislature. You see, each organ will be designed only on the basis of law. Please observe. Okay. First, the organ which creates law, then the organ which execute or implement the law, and then the organ which evaluate or interpret the law. On the basis of law only, all these three organs are created. So first, legislature, Article 79 is what establish your union legislature. It talks about parliament and what it consists of, all those things. Okay, so talking about legislature, immediately what comes into your mind? It is the parliament. Parliament consists of two houses. Their name I have mentioned here, Lok Sabha and Rajya Sabha, and you have states. States, if you come to, there are two types of legislatures. One, you will be having unicameral legislature. In certain states, there are bicameral legislature. I think there are 6 states of having bicameral legislature. Another 24 states, almost like 22 something remaining states are having unicameral legislature. Okay, here the bicameral, there are two names, which is Council of States and legislative assembly. Okay, upper house and the lower house. All these details not important, just for the namesake, how the organs are bifurcated. Okay. Next, you have the executive. Executive, immediately you understand there is a union government, central government, and a state government, where you have the president, here you have the governor, same council of ministers, and here council of ministers. And Article 53 talks about union executive. See, these articles are just glimpse I'm giving you. After 2 to 3 slides, we will start with the major confusion area. Okay, just have an idea. Now, judiciary. Article 124, I start with the basic judiciary, and then you have, these are the people who evaluate the law. When you talk about judiciary, immediately you get Supreme Court, then you have the high courts and all the system of lower courts. Okay, we know the organs, but what's special about them? What is the separation of powers? From where all these concepts originated? People say that it originated then back in 16th century. Aristotle was advocating the same. And later, it was told that in 17th century, there was a British politician, John Bowring. We're talking about, French politician was John Bowring, but British politician was a Locke. So all these three people were talking here and there. Okay, they did not give a clear-cut idea, but there was this one person who gave a big theory and a very good understanding. Yes, he is Montesquieu. So always remember, he is the father of coining separation of powers in a definite, defined terms. Okay, he is Montesquieu. Okay, I have got his picture. And where he has given all these sorts of understanding is in his book, that is The Spirit of Laws. Okay, these are all for introduction purpose. Now diving into the exact concept. What Montesquieu says. See, as I see the papers, when you are asked to write about separation of powers, many write there are different organs of the government separated from each other. That is separation of powers. Of course, it is the meaning that you have perceived, but what the thinker said, that's very, very important. So these three terms and wings that we are going to talk about must be memorized. Okay. First, Montesquieu theory told that there must be institutional separation or structural separation. What do you mean by that? Structural separation. See, there are three organs of a government. One member of this organ shall not be a member in the other organ. This member shall not be a member of the other organ. Say, for example, there are three classes. Okay, first standard A section, first standard B section, first standard C section. The pupil in the first standard A section will not be in B section, will not be in C section, right? So it is all separate, unique pupils for unique classes. That way, unique members for unique organs. That is the first thing. But unexpectedly, what happens? First, we will see what Montesquieu told, and we will compare with today's situation. Okay. Next thing, what he told is that one organ shall not, X means not, okay, shall not exercise the functions of the other organ. Very simple. I told you, right? Pupil of A class shall not go and do the work or homework of the B class student, and B class students shall not do the homework of the C class students. Very simple. Shall not exercise the function of other organs. Third point, one organ need not interfere in the function of the other organ. You see the difference? Doing others' function is something different. Interfering with others' function is something different. See, A class student not doing the homework of B class student, that is not doing the function. But A class student going and meddling with the homework of the other class student and saying that you do this way, you do that way, that is called as interference. So there are 3 points. First, the members must be separate. One member shall not be there in the other organ. Institutional separation. Next, you have this person, one organ shall not do the work of the other organ. Okay. Next, one organ shall not interfere, stop, or meddle with the work of the other organ. Simple 3 points. Okay. But you see, we have a lot of backlogs and problems in these separations. Practically, we'll see few things and then we will have a huge discussion. Okay. So when we're talking about this institutional separation, you take US, the US president is not a part of their Congress. Okay. So president is a clear executive and their Congress is a clear legislator. Okay. So there is separation of powers. But you take India, Article 79, establishing our parliament. It says parliament consists of both the houses and also the president. See how executive comes inside the legislature. So there is a but in the first situation itself. First point cannot be followed in India, not followed in India. Okay, next point you go. One organ not exercising the function of the other organ. You see the executives, the president and the governor, what power they have. Along with the executive power, they have the ordinance making power. What power is that? It is a legislative power. Okay. And pardoning power. What is that? It is a judicial power. Okay. And you talk about delegated legislation. The executive will make legislations. That's what is delegated legislation. And power to punish for contempt. That is regarding your legislature is having power to punish for contempt, right? That is a judicial activity. So you see, we give the name executive, but they are allowed to do some legislative work. You give the name legislature, but they are allowed to do some judiciary work. So it is all in a confusion. Second point, regarding second point. Third point, non-interference. But we have the concept of judicial review. Judicial review per se is interference. Interfering with others' job and seeing whether they are exercising their power within the constitution itself per se an interference. So there is a but in a third point too. So the point what I'm trying to say is, when you're talking of separation of powers, there is an opposite force which is like created in our constitution against the separation of powers, which is checks and balances. So we are going to today see the separation of powers and checks and balances. See, you have some separation and you have a but area where you come in for the checks and balances. This area is where there have been lots of questions repeatedly asked by UPSC. So let's see the previous year analysis and quickly learn the answers for all these topics. Okay. So let me get help of few students who can read and help me out. First question will be read by Sakshi ma'am. Next question by Pragyati ma'am. Next by Manasa ma'am. And next by Litika ma'am. And next by Ramdeep sir. And Rajeshri ma'am. So we'll quickly do all these things. Yeah, please do start.
Hello, ma'am. How are you?
Doing good, ma'am. Thank you for that.
Okay, ma'am. Thank you. Ji. The first question asked in 2022, in the parliamentary system, though there is no separation between the legislature and the executive in terms of personnel, there is separation of function between the two. Explain in the light of relevant judicial decisions.
So next question, please. Someone? I pointed out, right? Yeah, please. I'm so delighted to see faces. So I'm happy. Please do read, ma'am.
What is meant by the doctrine of separation of powers? Is strict adherence of the doctrine possible under a parliamentary form of government? Discussed with the help of relevant case laws.
We have the next question. 2017.
Yeah, ma'am. Do you think the current trends in judicial activism in India are inconsistent with the principles of separation of powers, which is considered to be one of the basic features of the Constitution?
Excellent, ma'am. So next question.
Examine the doctrine of separation of power. Also mention the relevance of this doctrine in the India.
Okay. Yeah. Ramandeep sir is not here?
The
Yeah.
Constitution of India merely subscribes to threefold division of gubernatorial function and not to the doctrine of separation of powers in its absolute rigidity. Comment.
Okay. So the basic thing, what they are asking is, they are asking, we don't follow separation of powers in a rigid form. That's what 2013 question means. I'll point out other people for reading quickly. Rajeshri ma'am, I told. Then Sai sir will be reading, and then Vikas sir. Yeah. Yes, ma'am. Please do, ma'am. Yeah. I'll move on, ma'am. Comment on the significance of the doctrine of. Oh, okay. Thank you. Next question. Sai sir, can you please read? He's reading.
The judiciary, by aspiring the powers of the other two organs of the government, in certain matters has diluted the theory of separation of powers. Do you agree? Examine critically.
Okay, done. Next, Vikas sir.
Yes, ma'am. The doctrine of separation of power in its classical sense, which is functional rather than structural, cannot be applied in any modern government discourse.
So we have read all these questions. Now we can find out what are the important areas. You see a lot of things modeled in a different way. Pay keen attention to all these questions. In fact, it is asking only 3 concepts in a different form. First one, it asks how a parliamentary form of government can adopt this doctrine of separation of powers. Whether this doctrine of separation powers is absolutely, rigidly accepted by today's Indian government. Is it actually possible to have such structural separation of powers in the rigid sense? Okay, that is the one thing. So these 2 points are actually related. And the third point, what they are asking is, yes, judiciary is overstepping itself by using judicial activism. How this is creating an imbalance in our separation of powers. So only these areas are repeatedly asked in several ways. Okay, I hope you agree with me. So entire today's class will be concentrating on these points. Okay, let's go to the class. Yeah, we saw that Montesquieu was advocating on separation of powers, but what is the reason he is stating that the powers must be separated? What is his rationale for separation of powers? I don't give a general rationale, it is the rationale of Montesquieu. Okay, we'll see that. First, he says that when the executive and the legislature are the same old person, there will be a danger posed. What danger? The legislature will be creating oppressive laws, and the executive will not be worried because they are the same person. They will try to implement these oppressive laws. So they try to secure everything to their own ends. That is, they can create a scam. They can be a legislature, and again they will implement only the schemes they want, where they will be having a lot of funds and where they can benefit. So what type of government it will result in? A despotic government. That is one view. Next, he says that, see, the law agency which enforces the law and the agency which enacts or creates the law will be the same person. So what type of law we will be getting? An arbitrary law, right? When the law is arbitrary, the judiciary cannot sit quiet. It will start legislating in the name of interpreting. It will start legislating the laws. Okay, that's what happens. So the judicial work from the interpreter goes to a legislature, which creates an imbalance again. That's second point. Third point, he imagines when all these 3 organs are under one person's control, automatically it comes to tyranny. So these are the 3 points given by him, but we have other rationales too. I've got a chat, let me check. Manasa ma'am is asking, can we say separation of powers is the antithesis of checks and balances? Of course, they are corollary forces. For every force, there is an equivalent and opposite force, right? So that's how with separation of powers and checks and balances. Good one, ma'am. So let me continue. So he's telling separation of powers. This is the theory, 3 points. And why I started the separation of powers, he gives again a 3 points. But basically, what is the aim of the separation of powers? Very simple. It is to preserve human liberty, because despotic government, monarchic government, what it's going to do? Oppress every individual. To save individual liberty and humanity only, the separation of powers is created. From all these concepts, we can denounce some 5 to 4 points. What are the actual use of this separation of powers? First one, as I told you, to keep away the autocracy. Then to safeguard the individual liberty. And most important thing, we are always concerned about ourselves. But what the government does, if a single person is responsible for too many works, there won't be any efficiency. Yes, separation of powers is most important for efficient administration of a state. Okay, then judiciary will be independent, and this independence will be maintained. See, if others not allowed to interfere with judiciary and judicial work is totally separate, then your justice will not be ruined. Okay, that's one point. Next, you prevent the legislature from enacting arbitrary law, and also from executive from doing any act which is arbitrary and which is despotic. Okay. So these points, if they are asking the usefulness, why do we have separation of powers, or in conclusion, you can use these points. So this important is separation of powers. It is very, very, very important for a function of a government. Same importance was recognized in Keshwananda Bharati versus State of Kerala. They told that separation of powers is a basic structure. Okay, remember that. Now we have seen the positive side of separation of power, but there were critics against this Montesquieu. What are the criticisms? First thing, they say it is unhistorical, which means nowhere there was exact separation of powers. UK did not have separation of powers. Britain, you know about Privy Council, right? What is Privy Council? Can anybody tell me? Anyone, if possible? Okay, I'll say Privy Council is the highest member body in UK, which was constituted with certain members who will be the judges, highest court of record there in Supreme Court, like the Supreme Court in UK. Okay, and they will be the highest persons of the cabinet-like system, Council of Ministers. They will act as the chief executive too, and also they will be a part of their parliament. Privy Council is a parliament, part of a parliament, which will do all these works. So they were a group of people, privy councillors. They were very, very powerful, who performed all these three jobs. So there was no basic separation of powers in then UK. But now, after the Constitutional Reforms Act, everything, there is a quite good separation of powers, which we follow here. Almost same is applicable there. Okay, they separated even the crown from most of the works. Okay, but earlier, there were no separation of powers. That's what they called as a criticism. So separation of powers were not present practically anywhere. So you created something new which will not work. That's what everybody criticized. But US is always known for separation of power. I'll say how it is separate. In the same time, it has judicial review. Okay, so every country you see, they have adopted some amount. If you see the scale like this, here you have separation of powers. Here you have the checks and balances. We have strike somewhere here. UK has strike somewhere here, and US has strike somewhere here. This is how we stand. Okay, so in every country, there is separation, and also there is checks and balances. But Germany has a unique system where there are 5 organs of government which was given, and it is a different system. But we need not worry about that. We'll see only about these 3 countries just as a starter. Okay, no question is going to come from there, just for the understanding. Now, next criticism. They say it is not mathematical. What do you mean by that? You cannot draw correct lines and say, this is what is executive, this is what is legislature, and this is what is judicial. Like that, you cannot draw a line practically. So second criticism. Third one, the proper function cannot be done. See, say for example, there is legislature. Their duty is to make laws. They are making laws, so they want to discuss everything. But while discussing, if they are talking against anyone, if that is amounting to defamation or something, then immediately someone will put a case and judiciary will intervene. If that happens, then they cannot make a proper law. They cannot freely talk with each other. That's why we have this parliamentary privileges. What this privilege says, yes, any problem within the parliament discussing about law, no one can interfere. So this is something like, you see, for proper function, they must be given the power of contempt, which is a judicial power. So when you're talking about separation of powers, this legislative organ not given judicial powers of contempt, they cannot do their essential functions of creating law. You see how it hinders. So separation powers is a wrong theory. That's what they mean. Okay. Next, if you see, regarding the state, earlier your state was very like a monopoly state, monotonous, doing only proper strict sovereign state jobs. But today it's a welfare state doing a lot of jobs. Being so, separation of powers is not possible. That's what everybody says, and this everybody what says is not a lie. Actually, it is. So absolute separation of powers is only applicable in an ideal state which is not existent anywhere. So what type of separation of powers we need today? We have a modern modified separation of powers. That's what I'm going to give you now. Okay. First, to create this modern separation of powers, we must distinguish between the essential and incidental powers of each organ. You know, we have 3 organs. We must know what is the essential function of each of the organ and what is the incidental function of each of the organ. First, you try to differentiate this, and then you make sure that one organ does not go into the essential function of the other organ, does not encroach into the only what? Essential function, which means they can exercise the incidental functions. That's how our entire constitution is made today. Okay, so what are the principles that you can denounce from this type of mechanism creating modern separation of powers is that first principle: executive, legislature, judiciary must be independent of each other and they must have their own essential functions, and others shall not interfere or take away these essential functions. Next, you have this, like, see, some limitation, that is, one organ shall not perform the function which belongs to the other organ. That's what I have told here. Essential function shall not done by others. So basically, there must be separation, and one does not function to the essential function of the other organ, but they can take the incidental function of the other organ. Okay, this will be very clear if we go on with the constitutional structures. Okay, I have pointed out 3 basic areas where you can study the checks and balances and separation of powers, how it is built in our constitution. Okay, these are 3 examples, and then we are going to dive into the serious issues. Okay, first, let's see Article 50. It places an obligation on the state to do what? To separate judiciary from the executive. But you see, it is only a DPSP. It is not enforceable. So separation of powers in strict sense, but not in an enforceable area. How sad it is. Okay, first thing. Next, you see Article 53 and 154. They say that executive power is vested with, that is union executive power vested with the president. Same, likewise, the state's executive power is with the governor. Okay, that's what it says. But you have the Council of Ministers who will be aiding and advising them. So there is a separation of power given, and there is a checks and balance given. And also, to enjoy this separation of powers, you have the immunity also given. You are the executive and you are free to do anything according to the constitution, and no court will call in question. So this is a separation of power. But they say you act in the aid and advice of the Council of Ministers. You can ask me, Council of Ministers is an executive. Of course, they are executive. But remember, they are taken from the Parliament. Parliament is their root. That's why I say it is a checks and balance. Okay. Next, you see the third area. That is, legislature cannot discuss the conduct of the judges. Okay. There is clear separation of powers between the legislature and the judiciary. But they are the people who are going to impeach the judges, right? So there is a checks and balance. So here we are in a scenario when we are reading separation of powers, we have to read the doctrine of checks and balances. That's why I gave you how it is intermingled. Okay, we'll see the doctrine. This doctrine is simply worded in Britannia dictionary. I loved it, so I'm reiterating the same. Someone please help me read it. Who will be that person who have never spoken in my class? Miss Licha, I'm seeing you first time, I guess, ma'am. Licha, ma'am, you're there?
Sure, ma'am.
You're the first time attending this class?
No, ma'am, this is my 3rd time.
Okay, I'm happy that you can read it now. Please do, ma'am.
Okay. Checks and balances, principle of government under which separate branches are empowered to prevent actions by other branches and are induced to share power.
Okay. Simple. Checks and balances means you have each organ is having their own power, but at the same time they cannot go beyond certain power. If they are traveling beyond certain power, this organ will come and stop it. That's what practically is checks and balance. Okay, now we will see how it is, how we are going to read this complex concept. Okay, how I have planned the same. You see, there is separation of powers, which means I told you, right? There will be a separate executive, separate judiciary, executive, judiciary, legislature. That's separation of powers. But if executive goes beyond its area, who's going to ask? It will be the judiciary coming and asking and the legislature coming in and asking. Same applies for the other two organs. This is what is checks and balances. See, we always think that this separation of powers is affected or like there is a problem, opposite force is only from checks and balance doctrine. But you have the other issue too, which is called as superpowers. This is a normal term which is used. Superpowers means executive will be given the power to legislate. Executive will be given the power to act like a judiciary, quasi-judicial actions. Same way judiciary will doing administrative work, will be doing legislative work. Legislature will be doing the judicial work. So they do a work of the other organ. Maybe it may be incidental work, but it is something beyond their power. That is called as superpowers. So how we are going to discuss today's class is like this. You see, the entire constitution will be like a web for today's class. That's why I have arranged it in such a manner. First, you'll be seeing the separation of powers of each organ. And then you will see the checks and balances in each organ. And then you will see how each organ is exercising other functions organs. Okay, other functions of other organs. So this is the step-by-step process we will be doing today. Hope it is visible. I'll just try to like make it bigger. Many people was asking me how to make notes. That's why I have made notes and I made a PDF. I guess it would be useful if while I was taking notes, I would be taking like this, just 4 sides or 3 sides for single class. That's all. Okay. So we will start with the creator of laws, legislature. You see, we are going to talk about separation of powers first. If you see the parliament, Article 79 says there shall be a president and there shall be 2 houses. And if you see state legislature, as I told you, it can be unicameral, bicameral, but it will always contain the governor, and Article 168 establish it. But if you see the executive power of the union vests with the president, the executive power of the state vests with the governor, but such vesting article will not be there for legislature. But who says the legislature is going to make laws? In which area, in where the constitution talks about this? That's why we go to the legislative procedure articles. You see, always higher number, it goes for state. Always lower number of article, it goes for union. Okay, likewise, you remember. So there is no separate article like executive giving you vesting powers. But the legislative powers, legislative procedure given by our constitution is the real power of legislature. They say the bill will be introduced in this house of legislature, which means a bill cannot be introduced in a court of law. Okay, this per se is vesting of power. There need not be any particular words. One thing. Next, let me scroll. Okay. Next, if you see legislative privileges, whatever I speak, only I can take action. So parliament has privileges under 105, state legislature 194. So whatever I speak, others cannot interfere. This per se is a separation of power. Next, you talk about salaries and allowances. Legislature is the best thing to work at, because they can fix their own salaries. Okay, state legislature will fix their own salary under Article 195, and same applies for the parliament. So nobody fixes your salary. In a way, you are independent. There is a separation of power. Okay, one thing. But this is not the case for Supreme Court judges and even for the president. Okay, it will be the parliament who's fixing their pay. Okay. So next, you're talking about contempt procedure. This in a way is included in your legislative privileges itself. So legislature will take contempt action, but you always remember their contempt action is limited. It cannot run to calling a judge under contempt or advocate under contempt. We have seen case laws on that point. Hope you check those cases. Okay. Next, you talk about 122. That what it says is that court cannot discuss any proceedings that have been taken place in the parliament. Same for the state legislature. It is all a non-interference, which is separation of powers. Now we will see the opposite things. 2 things. One is superpower. Next is the checks and balances. You see, checks and balances, directly it hits. First thing, how the members are appointed. While appointing, they will be taking oath and affirmation before the president, if they are parliamentarians. If they are state legislature, they take before the governor. It doesn't have any practical like curbing of anyone. But you see, if you go before someone and take a allegiance, it means this person is almost having a check on you, right? So it is like a moral checks and balance, one thing. Next, you see the composition per se. The parliament contains of two houses. If it is like that, there is separation of powers. But they call it president and governor is also part of your legislature. President and governor, they are the supreme executive heads, but they are part of your parliament. Okay, you see how it is. But this is not the case in US, we always know. But in UK, the crown will be a part of legislature. Okay, we have followed the UK parliamentary form of government. So that's why there is a huge check and balances where we cannot follow separation of powers in the strict sense. Okay. Next, to talk about assent. This president and governor, they are not like puppets just present. They must be giving assent. Only when they give assent, the bill will become a perfect law. But you know, they will be acting on the advice of the Council of Ministers. So who are the Council of Ministers in a way? They are executive again. You can call them legislature, and also they are active executive. So this is how parliament in a way controlled by your legislature, I mean your executive. Okay. Assent, you see, governor's assent. Actually, I need not say each and every article. It is just there. So please do write it along. Okay. Next, calling for proposals of legislation. Yes, the president and even the governor can call the houses to be present, that is the members to be present, and ask them to deliberate on particular proposal of legislations. Okay, it is not the, I have got a question from Sakshi ma'am. Ma'am, C and balance are supplement to SOP. I don't understand how they anti. Checks and balance, you see, Sakshi ma'am is asking that checks and balance is supplementing your separation of powers and how they are against separation of powers. Very simple. What is separation of power? One organ need not interfere with the work of the other. But what is judicial review, ma'am? You tell me. Ma'am, you hear me? Can you tell me?
Yes, ma'am.
Yeah, what is judicial review, ma'am?
Ma'am, when legislature legislate on something that is not, that infringe
constitution,
then judiciary can interfere or can.
Yeah, so judiciary is interfering with the legislature.
Yes, ma'am.
Of separation of powers, ma'am.
I'm sorry, ma'am, I can't hear you. Your voice is so low.
So you say judiciary
yes,
interfere with the legislative work. It will come inside and say what is right and what is wrong. This interference is against a strict sense of separation of powers, right, ma'am?
Yes, ma'am.
That's why I call it checks and balance is the opposite force acting on separation of powers. This judicial review is a check and balance. You get me, ma'am? When you go beyond the power, you are stopped by the other organ.
Oh, ma'am, in separation of powers, there's no need to have check and balances.
Yeah, that's what is the
in
strict
US
sense of Montesquieu. No. US also there is judicial review. US
yes,
there is judicial review.
Yes,
but strict sense of separation of powers has evolved by Montesquieu. The 3 points I gave you, right, ma'am? That is a strict sense. So that cannot be followed in today's scenario in any country for that person. That's what is today's argument, ma'am. That's why we are trying to say.
Okay, ma'am.
Yeah, ma'am. If you don't still understand, please put the doubt, ma'am. Let me try to clarify, because whatever I say need not be convincing. So I would try all sorts of things convincing people. Okay. So let me know.
Okay, ma'am. I will if I found something. Okay, ma'am.
Done, ma'am. Okay. So talking about proposals of legislation, the Council of Ministers, when they are making any proposal for any legislation, actually they are the operative part. They are doing any proposal for new legislation. The president can call for such legislation to be proposal to be discussed with. That's what Article 78 clause B says. And the president will be the person who will be summoning the houses. Okay. And the governor under 174 summoning the house. The autumn session, the winter session, the summer session, right? So all these things, who will be calling in, whose name it will be called? It is the president's executive's name. Okay. Then you see, there will be president can give address in every session. That is, he can ask everyone to be present, and he can give his idea on how a law should be proposed, and all these things he can give. Same, he can give special address, which is a compulsory address for starting of a new government. Okay, that also he'll be doing. And the most important, we talk about dissolving of Lok Sabha, right? When the 5-year term is over, or the government fails, or the Prime Minister advised for the dissolution of the Lok Sabha, in whose name it will be dissolved? It is the President's name. Okay. Then President will have the power to nominate MPs too. 4, 10 MPs, those things are there also. And you're talking about disqualification of any members of the Parliament. It is the President, yes, on the opinion of the Election Commission and the Council of Ministers, he acts, but he is the authority who can disqualify a member. So all these things, you see how other organs places a check on your parliament, legislature. Okay. But you always remember, President, he can act, but only under whom? Council of Ministers advice. Okay, that we have to remember. Next, you have the other superpowers. How legislature is having the power of judiciary. How legislature is having the executive powers. Talking about executive powers, it has the whole power and whole control to take care of its matters, day-to-day affairs. Day-to-day affairs means the legislature will have a lot of departments. Even a press department is there. And also, you see, there are a lot of advocates working and drafting committee members working, lots of committees and departments. Maintaining them is legislature is going to make rules, and only this is going to execute that rules. So it is doing the executive power too. So lots of committees are there. And when you're talking about executive function of a legislature, you cannot forget the legislative secretariat. In state level, legislative secretariat is established under Article 187, and under Parliament 98 established the same. So they will be responsible for the complete running of business and all the executive functions, which the entire Parliament can be regulated. Parliamentary secretariat and state legislative secretariat will be helping them. Okay, one thing. Next, talking about judicial powers they are having. Power to punish for contempt. Who has this power? Essentially talking, it is the judiciary. They do have this power, right, under the privileges. So that is one judicial power. And when you're talking about anti-defection, everybody knows what is anti-defection, right? If anybody doesn't know, please put me a word. When you're talking about anti-defection, immediately the court cannot come inside and say yes, no, nothing like that. It is the speaker or the chairman who will be talking. Anti-defection under which part of Constitution? 10th schedule, which is per se called as anti-defection law. And paragraph 6 says that the speaker is the final say. And paragraph 7 say that no court shall interfere in anti-defection issues. Okay, that is one judicial power. Next, see, any parliamentary session is going on, it shall not talk about court. That's an ancillary thing that I have to tell you. Okay. Next, when we're talking about impeachment of judges, see, in impeachment, each and every person sitting and voting will judge, okay, when the outcome comes in, depending on someone's voting, one's right is adjudicated. So impeachment of judges is in essential, is an adjudicatory work like per se, which is a judicial work. When you're talking about impeachment of judges, most important case is Veeraswamy. Justice Veeraswamy was Union of India. I think he's the only judge against whom there was impeachment proceeding. I think so. So this, what happened, I think the Congress party abstained from voting anything. So whoever was present in voting gave the votes. But since one party stopped the voting, there was no majority, so he was not impeached. Okay. Now we have seen all three areas of legislature. Now let's go to the next part, which is judiciary. Okay. Judiciary, where established under the Union, you have the Supreme Court, Article 124, and you have the state high courts, which is 214. Okay. If you see, there is no article, as I told you, which says judicial function shall be vested in Supreme Court, shall be vested in High Court. But where we say judicial functions are only to the Supreme Court and High Court, from the various jurisdictions that is given. Okay. You see, the 136 special petition only to Supreme Court, which means the legislature cannot entertain such special petition. Original jurisdiction, see, 32 writ jurisdiction, 226 writ jurisdiction only to Supreme Court and High Court, which means there can be no writ which lies to the legislature. That is per se vesting. Okay, that is a clear-cut separation of powers. Next, you see appointment. This appointment itself has in itself the separation of powers and also checks and balances. How? because when you're talking about appointment of Supreme Court and High Court judges, even transfer, in whose name it is done by the president. Then we had the NJAC issue, first judge's case, second judge's case, NJAC issue, and finally we resort back to collegium, which means the final say will be with the judiciary. Okay, that's what we saw. So if judiciary is able to appoint its own members, it is a clear cut of separation of powers. Nobody is interfering. But there is an area of checks and balances too that we will discuss later in the second area. Okay. Next, you see the parliament. That is one thing. Yeah. Parliament, I mean, that is the judges cannot talk about the parliament either, and vice versa, the parliament cannot talk about the judges. Okay, so state legislature cannot talk under this article and parliament cannot talk under this article except for impeachment. So this is a separation of powers per se, and you have a very good article, even though it is a DPSP, it is a moral guiding principle which says that you separate judiciary from the executive. So classic clear case of separation of powers. So if you're writing about SOP, never forget this article. Okay, one thing. Next, you see, there is this article 144, which says that every authority like Comptroller General of India, Election Commission of India, whoever the constitutional authority may be, they must aid the Supreme Court, which means the Supreme Court is summoning some authority and asking to submit some report or scheme. It must be done. Okay, otherwise it will be violating this article. Next, you have the law declared by the Supreme Court, which is binding on all authorities. They say law declared by the Supreme Court is binding on everyone. Okay, lower court, everyone, even you, myself, and the authorities are no exception. So this is all separation of powers. Then you see court of record, which means it has power to punish for its own contempt. Nobody interferes and helps it. So it is a separation of power. Next, you talk about judicial review. Judicial review, I told you, it is a checks and balance. Now, why I am calling it as a separation of power? Anybody can tell me? Judicial review, I told you checks and balance, right? Now, why I call it as a separation of power? Abdul sir is there? Yeah, he's there. Okay, Abdul sir, please enlighten me on this point. How can you say judicial review is a separation of power? If at all you can say. What would be your argument?
Ma'am, I'm so sorry. I'm not able to recollect it now.
Let me try. If you see judicial review, you see from the angle of legislature, angle of executive, it is a checks and balance. But if you see judicial review here, what is the basic idea of judicial? To interpret laws, right? So it has the custodian and authority to interpret constitutions too. So judicial review means you interpret the constitution and see whether others are doing wrong. So it is an essential function of a Supreme Court under Article 13, even our high courts. So judicial review, in a way, when you view from the point of judiciary, it is an essential function, which is a separation of power. It only can do it. No others can do it. Judicial review is not with the legislature, not with the executive. So it is an essential function we can view in that way. It is a one type of discussion, although it has counter discussions. So this is one type I'm saying. It is in a way separation of power. But viewing for the other angles, that is the legislature and executive, the other organ, that is judiciary, is trying to interfere with their work, which is checks and balance. You see, checks and balance is like this, and separation of powers is like this. Only when they join, the entire circuit gets connected. So one without the other will be totally futile. That's what I mean. Okay. Now we go on to the next one. That is how judiciary is having checks and balances, one from the legislature and other from the executive. How it is done. Legislature, of course, impeachment. You talk too much, I remove you, like that. Okay. Next, although it can impeach, it cannot discuss the judge's conduct. You have to remember, whenever you're talking about impeachment, you have to mention this. And also, it cannot call the judges for contempt. Okay. Yes, it has checks and balances, but this balance per se has a limit. That's what it means. And next, you talk about major things, salary of the judges. It is the parliament who fixes both for the high courts and for the Supreme Court. So major two things of judiciary is with the legislature, your lifeline and your salary. Okay, see small two things, but these two things are small in number, but not in their veracity. Okay, next you're talking about executive. Executive, who is appointing the judges? Yes, the collegium will have the say, but it is executive in the name of the president only they are appointed. Okay, one thing. But the executive will play a vicious role here by using the IB report. So if the IB report is negative, no collegium will ask you again to do the same thing. They say this person is characterless. He cannot be a judge. Okay. So IB report is an important area. When we're discussing about the appointment, I told you about this IB report. Now going ahead, when you talk about judgment, they say arrest this person, put him in jail, give them this compensation, and what all they can say. This person can enter into this way of another person, something like that. So simply saying judgment, arrest Mr. A. Who's going to arrest? Is it the judge is going to arrest? It is the executive. So whatever I can say, I will have only teeth. See, I can only bite if I have a teeth, and this teeth is executive for the judiciary. Very simple. Okay, you see how they are controlling. Now, how judiciary is doing others function. First function, legislative function. Yeah, ma'am, I can't hear you for 2 days, but still I don't know why there is a problem.
Hello.
Yes, ma'am.
Ma'am, can you repeat the third point under legislature? Contempt doesn't give to judge and attorney or something.
Yeah, is parliament, if there is something going on and there is a problem, immediately they can start a contempt action, right? But this contempt action cannot call the judge or any attorney under the contempt of parliament. We saw the presidential reference case, right, ma'am? Lastly, it was under the contempt we saw. So that was the proposition I'm telling you. Yes, legislature has the power to punish for contempt, but it cannot call the judges and any other attorney. You understand, ma'am? It has a limited power. It can call anyone except these people.
Okay.
Yeah, ma'am. So I gave you a general idea. They can impeach, but they have limitations too. That's why I pointed out these 2 points. Nothing more. So we will go on other functions. What judiciary can do? Yes, it can legislate in the name of what? Judicial review. That is the major area. They call it as a pill to major area. A very good example is Vishaka versus State of Rajasthan regarding judicial review, judicial overreach. We are going to see in the last slide, but we will see it in a small sense. Next, we are talking about the administrative thing. What is there? The entire Supreme Court, you see, they will give you a list, right? This judge is present for this list, this portfolios they will be giving, right? Who is doing that portfolio work? It is the CJI. What work is that? Judicial work? It is an administrative work related to judicial. Okay, so allocation all the business and all the rules the Supreme Court is free to do under Article 145, which is an administrative work. And the High Court is having the supervisory power to all the lower court, 227 and also 228, which talks about transfer of cases and whatever business you do, I do, it is all regulated. And this regulation is all administrative work. Okay, now we go to the final wing, which is executive. Yeah. Executive is where you can see clear-cut separation of powers. Yes, Article 52 says there shall be a President of India, and 53 immediately says executive power shall be vested on him. Likewise, in same Article 153 says there shall be governor, and executive power shall be vested on him immediately next Article 154. Although they are vesting the power, there is inbuilt check and balance. What it is, they must listen to the aid and advice of the Council of Ministers. Article 74 for the President and Article 163 for the Governor. But if you see what advice this Council of Ministers are giving to the President or the Governor, whether that can be asked by the other organs, no, it cannot be asked. That is in a way separation of powers. So first there is a separation of power, and then there is a checks and balance, and again there is a separation of power. It is like cascading on one another. Okay, you understand how it is done. Now you see, yes, aid and Council of Ministers necessary, but not in the discretionary power of the governor, right? So he has complete discretion, 163, but it cannot be malified. He is again, this is a separation of power, giving him a discretionary power, but It is not uncontrolled. Judiciary can interfere under name of judicial review when it is malified or unconstitutional in other areas too. That is a checks and balance. Okay. Then you see, president does not have a discretionary power, but he is the chief commander of the three forces. He can act on it, but it is the prime minister who will be talking about it. So how I am telling the entire story, there is a proposition and a but. So that is how executive is built on. A power, a check, a power and a check, like that. Okay. That's why I made this mind map sort of thing. Now, if you see, when you're talking about separation of powers, checks and balances, always our mind will be revolving around these three organs. But there is another major sovereign player which controls everything in a way. Who is that? It is we citizens of India. You see the Council of Ministers, they are the real executive, but they are collectively responsible to the Parliament. This is regarding the state, how the Council of Ministers under Article 164 is collectively responsible to the state legislature, same article for the Parliament. So when you're talking about collectively responsible to the Parliament, we in turn elected these people. Okay, this Parliament and the entire legislature is responsible to the people again. After 5 years, if you're not satisfied, we can change them. So in obedience of democracy, there is a checks and balance on the entire system by we people. We, the citizens of India. Okay. This also you can use in your answers, some unique points where you score extra marks. Okay. Now we'll see the separation of powers point under the executive. I gave you a picture. Then we see the points quickly and then we go. Okay. President and governor vested with executive power. Council of Ministers to aid and advise them, but it is not asked in court. And if there is any problem and this problem dispute or any issue is involving political question, then the court will not interfere. This is doctrine of political question and non-interference of court, which is a separation of power. And if you see judicial review, they will not come inside for everything. They will come only when your fundamental right is violated and the principles of natural justice is violated. Okay, they have a limited scope. It is not like an umbrella thing what they can exercise. We call it so, but it is somewhere umbrella also it happens. But you see, strictly when we talk, it is just a small narrow opening. Fundamental right violated, principle of natural justice violated, then only the judiciary comes in, which means there is a separation of power. Okay, now we go to the checks and balances. Okay, how executive is checked by judiciary? Yes, by the judicial review. Any laws made, any schemes, bylaws made, schemes made by the executive, if it is violating a fundamental right, it will be struck unconstitutional under Article 30 using what articles? 32 and 226. Gateways. Okay. Next, purely administrative actions. No, judiciary will not interfere. But if your principles of natural justice violated, if it is arbitrary, it will interfere. Okay. Next, you talk about legislature. See, this Council of Ministers is the executive. They are collectively responsible in a parliamentary form of government. That is a major check and balance. And talking about impeachment of the president. Yes, president will be impeached on serious misconduct and those 3 to 4 heads you have, that can be done under Article 61. Okay. But when you're talking about governor, there is no impeachment. He will be for serious misconduct. He will be removed under Article 155 by using a warrant and signed by the president, which means the Council of Ministers will remove him. It is like a political appointment and a political removal. Okay. Next, you talk about powers of the other organs which are taken into hands by the executive. Classical powers, not confusing, very simple. It has pardoning powers, which is the power of the judiciary. And you have the respective articles. Same ordinance making power, which is the legislative power, you have these 2 articles. And then executive has a major area of delegated legislation. Constitution nowhere talks about it, but you have the doctrine of delegated legislation, which is present in each and every parent law, which the legislature makes. Okay. So hope people can understand. I have tried making it very simple. Now separation of powers is over. We are going to see in the next area how judicial activism is violating this balance. Okay. You see judicial review, you know, judiciary interfering and looking and checking the balances, checking the areas of each and other organ and saying whether they are obeying the constitution or not is judicial review. Okay. When it becomes judicial activism or judicial overreach, Very simple. When the judiciary tries to enlarge its powers and try to do the work of the other organs, then it becomes judicial activism. So what are the articles involved in this judicial review or judicial activism? Both are same articles, but if it is amplified, used in the correct sense, it is judicial review. But if it is stretched out too much so that it transgresses other organs, it becomes judicial outreach or judicial activism. Very simple. You pull so much, okay. You pull this much, it is not acceptable. Okay. Let's see how judiciary starts doing legislature works and how it starts doing the executive work. This way I have separated. Okay. The articles I need not repeat, you know. Apart from 32 to 26, we have power to do complete justice 142 and also law declared by Supreme Court. So these are extra articles. Okay. We will see how judiciary legislates. Vishaka was the state of Rajasthan. What happened here? Can someone let me know? I'll just try to ask someone. Okay, I'm not able to see all the participants. I'll just check on participants. Mudassar sir is there. I'm just asking someone who I have not called today. Mudassar sir left. Okay, he's there. Okay, he left. Pragyati ma'am, can you tell me what is Vishaka versus state of Rajasthan?
Yes, ma'am. Against harassment of women at workplace were laid down.
Excellent, ma'am. Earlier, we did not have rules for harassment of women in workplaces. To fill in that gap, CEDA Convention was brought inside, and those principles were taken as rules in this judgment, and it was asked to follow. So there was a legislative gap. So this gap was tried to filled in by the judiciary. So it was a judicial overreach. But the outcome was a good outcome. If at all that gap is not filled, it will result in injustice. So it was done. Okay. So what question we are discussing here is whether there is judicial overreach. What are the cases of judicial overreach? Whether it is good or bad, it is up to you to discuss in own words. Okay. Next, you're talking about pill. Yes, pill is a stretch. It is a judicial overreach because you worried, you come before law. But the situation is not like that. The worried people are downtrodden. If we follow the law, there will be injustice. So law was stretched, judicial overreach in Husainara Khatun versus Union of India, first pill case by our heroine Kapil Hirangini, okay, the mother of pill. And next you talk about state of Haryana versus Bhajanlal. Bhajanlal case famously known for rules for quashing the FIR. Okay, that was a legislative, they say High Court and Supreme Court can quash the FIR, but under what circumstances they can quash? There was a legislative gap. So this was filled in. And next you talk about Bachchan Singh case. What happened? Yes, death penalty can be given. For what death penalty can be given? For murder, you give death penalty. But in murder itself, there are lots of differences. Yes, the legislature has made informed differences like culpable homicide amounting to murder, culpable homicide not amounting to murder. But this difference was not enough. They needed to even culpable homicide amounting to murder. They wanted several degrees of murder where there was small lacunae where death penalty can be given. That was set right by rarest of rare case doctrine in Bachchan Singh. You see, there is judicial overreach, interpreting law, creating new doctrines, but for the good sense. Okay. Next, we see how they are taking up the work of the executive. Okay. Perarivalan case, AG Perarivalan versus state. What happened? The Council of Ministers told that he must be pardoned and released, but the governor did not take action. So immediately the Supreme Court took sumo action under 142, doing complete justice and released this person. What the Supreme Court must have done? It must refer the matter to the governor and asked him to exercise his pardoning power. But the Supreme Court taken his power into its hands, which is in a way should be condemned, because it creates an imbalance in the separation of powers. It is my view, but see, I can give you only facts. As an aspirant, you must take what is positive and must be able to discuss what is negative on judicial overreach. Okay. Next, you talk about executive failures mostly lead to this pills. Okay. Husainara Khatun, what happened? Under trial prisoners were kept inside. Even though they have automatic bail, they were not left outside. 5 years, 6 years kept inside. This is an executive mishap. They are not active. They're not performing their function. That's why legislature had to interfere. So on releasing these people, they take up the work of the executive. Right, one thing. Next, in redistribution of essential supplies case, in the COVID, it is a governmental function to distribute vaccines, oxygens, and it is for the government to do it. But the Supreme Court earlier intervened and gave directions, and then it formed a committee and also went on abroad and saying a word on vaccination policy. Yes, it is a judicial overreach, but for the good outcome. Okay. And I have few other judicial overreach to inform. First one will be like, see, what judicial overreach does. It upsets the balance between the organs. And judges, if they start deciding policy issues, it will be like something we disrespect the democracy. Because whom we want to rule, for that person only we have voted. So we did not vote judges. Judges cannot make policy decisions in the name of judicial review. Okay, that's the next thing. It is an insult to democracy. Other areas of judicial overreach is classic NJAC. Yes, it is for the independence of the judiciary, but nowhere in the world history, judiciary has conferred the power of appointment of judges to itself by itself. Okay, it is like judiciary acting like a monarch. In a way, has lots of positive things and it has lots of negative things. Collegium is not transparent again. Judges are not like, see, good people are coming as judges, but they do have a lot of issues too. We are seeing in most of the judgments. Okay, so NJAC judgment is in a way like judicial overreach and a monarchy, calling for monarchy. And 1993, what happened? Few people were taken as hostages by militants. Okay, so the army people, army head, what he told that we will stop food supply to this area. So the militants will starve and they will come out. So we can defeat them easily. That's what is the plan. But the court intervened here and told that you cannot stop the food supply because it is not only militants there. There are hostages too. You have to give so much of food supply to them. Whether it is right or wrong, that's a different thing. But see, court how on humanitarian basis it has rolled out. See, hostages need not be starved, right? But if you see, the court shall not interfere in the executive major work, which is armed forces inside the military works and all. But yet it interfered. In this case of state of Jammu and Kashmir versus Jammu and Kashmir Bar Association. Okay, so it is an overreach. And next you see Keshwananda Bharati, whether actually parliament, you talk in the normal sense. Don't be biased like a judicial people. Okay. You see, they are the their predecessor is your constituent assembly, and then it changed to your parliament. Okay, then they must have the powers of their predecessor when we are talking about normally, because the High Court has the original jurisdiction and the letters of patent jurisdiction, extraordinary original jurisdiction, which the earlier High Court of Britain had before the independence. It has every power of the before independent High Court, and same for the Supreme Court, and it has even more higher powers now. Even Privy Council's power, every power is there in the Supreme Court. But they deny to give the constituent powers to the parliament. Okay, that is for the good. But you see how they are limiting. That is judicial overreach. And you talk about censorship of Jolly LLB too. You have the censorship board, and why the Bombay High Court must constitute a panel to see a film and see whether they are derogating judiciary. So that is something they go beyond their powers. But I see a positive thing in that, because the censorship board will see whether the content is appropriate for the adult or for a small person, or it is inciting any problem or something, they will see. But they will not regard anything regarding the the prestige or the integrity of the judiciary. They will not check whether they are defaming judiciary. Okay, that will not be done. That's why there was a committee held. Although committee held for a good, but it is not the function of the judiciary. When the judiciary does a function which is not its own function, essential function, then it is a judicial overreach. Okay. Maybe I may be biased with my personal opinion. That's why I say I'll give you facts and it is for you to decide the personal opinion. Okay. So any doubts, please let me know. And got one aspirant telling me regarding the amendment class or some class that the articles have not been read. Okay. Next class onwards, I'll try to, from earlier, I try to read the articles, but here and all, like reading article is not possible. If it is possible, I will surely read the article and give the concept. Okay, here we have we've spoken about more than 20 articles. That's why. Okay. So any other suggestions are invited with an open heart. Please do help us to improve the classes. Jolly LLB sentence again, ma'am. Very simple, ma'am. Rajeshri ma'am is asking a doubt. She's asking, can you explain Jolly LLB case? I'll tell you. In Jolly LLB, what happened? There was a case which instituted saying that it is derogatory, it is having derogatory scenes against judiciary. Okay, they are mocking the role of advocates. That was the case. So immediately Supreme Court that is Bombay High Court, I think. Bombay High Court constituted a committee. This committee had to see this film and say whether it is derogatory or not. So if you see any film for that matter, for censorship, we have the censorship board to see and decide on it. But here the Bombay High Court has constituted a committee and doing the work of the censorship board, which is a judicial overreach. That's what I say. Ma'am, am I clear, ma'am? Rajeshri, ma'am? And one more thing, my personal opinion, I say constituting such board is good because the censorship board will see whether the content is good or bad, whether it is appropriate for the kids or something like that. But it is the judicial person appointed. That committee will see whether it is derogatory against the judicial. So that will not be seen by the censorship board. So in a way, it is right to appoint such a committee. That's what I think. Spoiling the parliament's name. Sadly, it doesn't have the judicial review power to call for a censorship board. Yeah, thank you. Thank you. So, any other questions? Hope this style of taking notes suits for you people. If you take short like this only, you'll be able to revise at the end and you'll not make another bulk of standard books. Okay. This is especially made for, ma'am, the IB report for appointment. Can it be? Oh, thank you. Thank you, Rajeshri, ma'am. Abdul sir is asking a doubt. Ma'am, can the IB report for appointment, can it be judicially reviewed? See, IB report will be presented to the Chief Justice and the Collegium. Okay, practically speaking. The Collegium will go through and the IB report will have a final conclusion saying that, yes, this person is suited. No, this person is not suited. The IB report will be seen and if the Collegium is satisfied only, they will accept. If they are not satisfied, they will press again for the appointment and the executive will have no other say. They have to go for the appointment. But till now, as far as I know from my peers and everyone, if the IB report is negative, the entire list will be dropped. That's practically happening. Okay. Yes, IB report can be reviewed, but not in court, but not judicially, like a judicial review. It will be the Collegium will be revising it and seeing that whether it is proper. Only when it is satisfied, it will push it. Otherwise, it will not push it. Sir, am I clear for you, sir? Dul, sir?
Yes, ma'am. Yes, ma'am. Totally. Thank you so much.
Thank you, sir. So today, any other doubts? Please let me know.
Ma'am, apart from the classes,
I'll put the headset. I'll put the headset.
Yeah, for the constitutional and administrative law classes are over, or one or two classes are left, I think. One class, yeah. Will we continuously having the international law classes right after this, or we'll be having the gap? How it will be? Because I have to make some notes.
We'll not have continuous classes. What I proposed is that to the team, I want 4 days of holidays, and after that there must be a test in a Zoom call, which means everybody will be opening the video and they'll be writing in front of me, and on spot I'll be giving the question paper. I thought I proposed this, but I don't know how far they are accepting. Few people think that we must not force the aspirants, and I think that unless and until someone helps you push, nothing will be done. That works for me. Okay, that's why I gave this. So you will be having at least a 5 days of gap, and after that we will start international law. Many people are giving answer writing practice. Thank you for the same. I can say like few people will clear UPSC from their writing style itself. I have told to these people. So others also, please do take the writing test. We will have a test and then only international law, 5 days of holidays. Okay. Tomorrow is a holiday. Day after tomorrow only we'll be having the Lokpal. Okay. And
Yeah.
yeah. Rajeshri ma'am was asking a doubt. I could never make such note. Okay, okay. It was regarding notes. Okay. Oh, no, ma'am. Let me talk with you in person, Rajeshri ma'am, regarding notes. I'll tell you how you can improve taking notes. I'll help you out. See, taking notes is very simple. You have small hints and try to retain only the primary words, keywords, and for not use no, this into mark, and for yes, use a tick. If you do that per se, like notes will be very much simplified. Okay, so that you can easily revise in the last minute, because it is not a college examination having single subject. You have 6 fabulous big subjects, and that too for CLD. Imagine each topic is a subject. Okay, that's why. So any other doubts? Okay, happy Navratri. I wish you all success. I consider this as a family, and I think everybody must succeed with very good rank. Okay, I'll make law optional as much as simple as possible so that you get good marks in prelims and GS. Okay. Yeah, we'll wind up for today. Yeah. Thank you so much.